I'm going to start by doing some introductions, but just for our web viewers, welcome as well. And just keep in mind that everything we're discussing today is federal law, but United States federal law. So if you happen to be a resident of Canada or the UK, it's not going to necessarily apply to you. So the cases we're going to discuss and the statutes we're going to discuss are U.S. law or federal law in the U.S. So let me start by saying welcome to everybody who's sitting here as well. This is a pre-conference day for Autism One, Special Education Law Day, and I'd like to introduce our presenters. I'm Tim Adams. I'm a lawyer practicing in California. I'm only licensed to practice in California, so I know lots about federal law and lots about California-specific law, but I may not have all the details on everybody's state laws because there's 50 states and we've got all kinds of statutes that may apply in your state that don't apply in other states, and so I will do my best to address all the questions, but they will all be based on federal law, United States federal law. I wanted to take the time as well to introduce our other presenters. Lynn Arnold, if you can stand real quick. Lynn Arnold she's a parent advocate, but not the kind that represents parents for money. She does it all for free. And she is a leader of a local organization in California called Talk About Curing Autism, and she runs the TACA group out of Central California. And she's a great resource to parents, and she's graciously agreed to join me to help with the parents' perspective of this discussion today. And I'd like to welcome Lynn and thank her for her participation. We've also got Mitchell Perlman. Dr. Perlman is a clinical psychologist out of San Diego, California, and he has also agreed to help us with this presentation. He's going to be doing sections or segments of the presentation having to do with assessments and give you lots of very important information about assessments and why assessments, independent assessments especially, are needed throughout this process. So I'd like to welcome Dr. Perlman. And last but not least, we have Jennifer Kropke. Jennifer is a senior associate at the law firm Robertson Adams, which is my law firm, and she's an attorney that's been working with us representing parents of children with special needs, and she has agreed to help me with this presentation. We'd like to welcome her as well. She's going to do portions of the presentation. So let's start with our first section. I want to make sure that everybody's got a copy of this book. If you don't have a copy of this book, raise your hand, we'll get one to you. We got somebody in the back. Jennifer's going to get you a copy. Okay, this is going to be your workbook for today. This is going to be a long day, lots of stuff to go over. So we're going to ask that you hold as many of your questions as you can, unless you don't understand something that's written here, and I'll answer that for you quickly. Hold it until the 11 a.m. session. 11 a.m. we're going to have a panel discussion, and we only have 50 minutes to go through each one of these sections or segments. And so if you can just wait, write your question down. We give you a space in the side to write notes. And I'd be happy to address questions that you may have, even if we don't get to you in the panel session by email. So you can feel free to email me at TADAMS at attorneys.com. Also, info@edattorneys.com. We'll get to an attorney in my office, and we'll try to get a response back for you. Sure. TADAMS at edwarddavidattorneys.com. So the first thing we're going to do is we're going to start with session 1. This is a review of the changes to the IDA. As many of you probably know, or may not know, there's a law that governs special education in this country, and it's called the Individuals with Disabilities Education Act. And we saw this law come into being in 1997. Originally, had a predecessor that was called the Education for All Handicapped Children Act that goes back to the 70s, and then we had it reauthorized in 2004. And every time Congress makes a law that the president signs, it becomes law of the land. There are regulations the U.S. Department of Education comes up with, and usually there's some delay time So in 97, it took them a couple of years to come up with the regulations, and these regulations provide more detail and further interpret the law, and they become law as well. And the regulations for 97 were implemented and became effective in 1999, and the regulations for the newest, the reauthorized, the current law, which is IDEA 2004, they also added the word improvement. So some of you might see this as Individuals with Disabilities Education Improvement Act. We still call it IDEA or IDEA 04. And the regulations, this law became effective July 1, 2005, and the regulations became effective just last October 2006. Okay, so it took them quite some time to come up with those and put those into place. So what we're going to do is we're going to go over the changes. Some of these are in the body of the IDEA, and at least one of these are pursuant to the regulations that became effective in October 06. We're also going to talk about case law, and our U.S. Supreme Court has heard a lot of special education cases over the past 2-3 years, and we actually have one that was recently decided as of Monday, the 21st. And so it's not in the book because these already went out to print by the time we got that decision from our friends on the U.S. Supreme Court. So they actually ruled in favor of parents at Winkleman versus Parma School District, and decided that parents could represent their children all the way through the court system. Previously, there were some circuits that decided that wasn't appropriate, that a parent had to hire a lawyer to represent their child if they wanted to bring this through the court system. So let's go through the changes, and like I said, let's hold the questions till the panel discussion. Depending on how quickly we get through this, I can take maybe a couple, but I think most of them will have to wait until 11 o'clock. So let's start with the recent changes to special education law. The IDEA has a statute of limitations, and previously under IDEA 97, they didn't have a set statute in which you could bring claims under this law. They left it up to the states, for the most part, just to come up with their own statute. And depending on the state, you might have had a year or 2 years or 3 years. In California, it used to be 3 years. But the Congress decided to go ahead, and unless the state came up with its own, they said, we're going to make it a 2-year statute of limitations. And what does that mean? Well, if you have a claim that you'd like to bring, and it's older than 2 years, and you file today, then you can't bring claims that are older than those 2 years back, okay? And typically the way the IEP works, the process works, is that you have an individualized education program that will control for 1 school year. So it'll control 1 school year starting usually at the child's annual review date, and if the child has transitioned at age 3, we're talking about whatever that birth date may be. Could be in the beginning of the school year, starting in September if it's a traditional school year. Could be any time during the rest of the year, and they would have to hold the IEP by that annual review and control for the rest of that school year and up to the remainder of the school year for the prior or the subsequent year. So we're looking at 1 school year. And so if you bring claims under the IDEA, you're looking at 2 years, or not necessarily school years, but just 2 calendar years back from that date. And that's the statute change. And you see an example. Statute of limitations is the amount of time which you're allowed to wait to file a due process complaint. So the example I gave is if you have an IEP that occurred on July the 15th, due process complaint was filed on May the 13th. July the 15th, 2005 was filed on May the 13th, 2007. And the IEP meeting is within the statute of limitations, okay? So that's the example, and I think that if you have any questions about that, how that works, feel free to ask me at the panel discussion. Let's talk about a couple of cases. The first case I'd like to bring up is the Schaefer versus Weiss case. It's a U.S. Supreme Court case that was decided in 2005, and depending on your state, there was a split there's 11 circuits in this country, 11 circuits of federal courts, and sometimes the circuits have different opinions on how the laws should be interpreted. And depending on the circuit, different school districts sometimes had the burden to prove that they offered a free, appropriate public education, and other times, regardless of who filed the complaint, a due process complaint, and other times the parent had the burden if they filed the due process complaint. So the circuits were a little torn. Well, if you file the complaint, do you have the burden to demonstrate your case through this process, or regardless of who filed it, does the school district have the burden to show that they offer this free, appropriate public education? Well, Schaefer versus Wiest settled that and decided that whoever files the complaint has the burden, okay, for the most part. Now, there are some exceptions to that, because if a parent has withdrawn their child from a program within the school district that they feel is not appropriate, or a program that has been offered as part of an IEP that they feel is not adequate, or they disagree with an offer that the school district makes, and the parent places their child in a private school program, then the parent has the burden to demonstrate that that private school program is appropriate and that the school district program is not appropriate. So in that case, the parent still has the burden regardless of Schaefer versus Wiest. But in other situations where the parent is disputing the IEP and the parent brings the claim, the parent has the burden. That's what Schaefer versus Wiest says. And if the district brings the claim, the district has the burden. So they've got to put all the evidence, and they've got to prove to the administrative judge, sometimes they're called hearing officers, sometimes they're called administrative law judges, that the district, either if it's a district filing, that they provided a FAPE, free appropriate public education, or if it's a parent filing, that they did not provide a FAPE during that school year at issue or school years. Let's talk about the next case. Next case is a 2006 case, Arlington Central School District Board of Education versus Murphy. Interesting case. Under the IDEA, as many of you know, you can collect your reasonable attorney's fees if you're the prevailing party as a parent in an administrative action. So if you bring a claim against your local school district and you are found to win your claim, and you win enough so that you'd be deemed a prevailing party in different circuits. We talked about the 11 circuits in this country. They have different interpretations of what it means to be prevailing party, but let's just say you're the winner, you win all the issues, and you get back what you're asking for. Then you prevail, and you can collect your reasonable attorney's fees as part of costs. And that's how it's worded in the IDEA. There are some circumstances in the new IDEA where school districts are allowed to collect their attorney's fees if the parent has filed a frivolous, or the parent's attorney has filed a frivolous claim, and it's a very high standard. So if you have a claim with some backing, say from an outside expert like a psychologist or a therapist, and that person feels that the program offer that the district made is not appropriate for whatever reason, and you're bringing that claim based upon this information or based upon a personal belief, and you've got some evidence to show that your claim, it's rarely going to be a frivolous claim, but I just wanted to mention that as an aside, that that's also a right for the school district to collect from parents, but only if it rises to the level of frivolous, unfounded, without merit. It's got to be a pretty poor claim for the school districts to recover fees from the parent. But back to the parent's fees, if you are the prevailing party, you can collect your reasonable attorney's fees as part of costs. Now, we had for many years been pursuing the cost of expert fees, okay? People that go to testify in a due process hearing, people who are like Dr. Perlman, who would be, say, a clinical psychologist who'd done a report, who had done some preparation, who shows up to the due process hearing and provides their insight and testifies as a witness and discusses what their feelings or thoughts are about the child's needs and makes recommendations. That person is an expert witness. Typically, these people charge for their services, and that's okay because everybody's got to make a living. So there is a cost to the parent, which sometimes is very, very expensive depending on how long the hearing is, how involved the preparation was, how complex the case is. And those fees in Arlington versus Murphy, the U.S. Supreme Court says are not collectible, that the IDEA did not provide sufficient notice to school districts that they would be obligated to pay for these expert witness fees. Therefore, the U.S. Supreme Court says, parents, if you hire an expert, you go to due process hearing, even if you win your case and you're the prevailing party, you can get your reasonable attorney's fees back, but not your expert fees. There were some circumstances where a parent might have had a parent advocate and parents were also looking to collect the cost of a lay advocate, a non-licensed, somebody who's not a licensed attorney in that state. And I think there are issues as well having to do with that. But the primary focus of the discussion, the Supreme Court case, was about experts. Okay, so we're not happy about that case. I think it's really difficult for parents to afford to pay for experts and know that even if they win hands down, they're not going to get their expert costs recovered. Obviously, school districts have greater access and ability to have their experts, people that are usually most often employed by them, psychologists and therapists, come and testify, and they're paid a salary, and they show up and they do their thing and they do their preparation with the district's lawyers, and that's not really an extra cost per se for the district, although they might lose a day in their classroom or whatever job they may have, or day of testing of other children. It's not going to be the same level of cost, but unfortunately that's what the U.S. Supreme Court has decided. Therefore, if you plan to use experts, we're going to talk about ways in which you can reduce your costs, and one of those ways is if you start out with an independent educational evaluation. We're going to go into lots of discussion and give you details about that as part of our strategy discussion. There are ways to recover costs for independent educational evaluations, but we'll separate those out into what differentiates an IEE from an expert. And sometimes they're one and the same, and sometimes you're able to characterize a lot of the costs related to the expert as part of an IEE, or an independent educational evaluation. Another major change to the IDEA is the district's obligation under, if you look at number 4, to use research-based, peer-reviewed research-based methodologies. Okay, what does that mean? Well, school districts are obligated to use a method of instruction and to identify that method of instruction in the child's IEP it's based on some sort of study that's been peer-reviewed. So if you have a method of instruction and there's a study that came out of Harvard or Yale or Stanford or some other university that's of reputation, then it's likely that's going to be deemed a research-based, peer-reviewed methodology. Okay, there's lots of methodologies out there. Some of them are not peer-reviewed, research-based, and some of them are. So it's more likely that if you're a parent, you're able to substantiate a request for a particular type of method of instruction, a preferential method, if it's research-based. Under item 5 on page 6, IDEA 2004 found that we need to have high expectations for our children with IEPs. Make sure that we're hiring highly qualified staff to provide them instruction, and it's imperative that the high expectations be reflected in more challenging goals. Okay, there's a bit of a conflict, because we're still a U.S. Supreme Court decision that's controlled since even prior to IDEA 97 that talks about this definition of a free appropriate education, free appropriate public education, and what that means, and that's the Rowley case. Rowley versus Board of Education defined it as a basic floor of opportunity, not the best education as some other courts have further defined it, but I think that there's a swing, or there's a turn towards providing more of a maximum opportunity, even though it's not there yet. We're not seeing that the courts have found it. There are some courts coming out of our Ninth Circuit, which is in the California area, that seem to think that the IDEA has raised that standard, but as we see it right now, the Rowley standard, which is that basic floor of opportunity, just getting the child's foot in the door, still applies. Okay, so the school district won't necessarily have to, as some courts say, provide a Cadillac of an education, but just a Chevy. Yeah. Rowley? It's R-O-W-L. I believe it's E-Y. And that's the premier case in defining free, appropriate public education. We're hoping to to get some better interpretation of FAPE standard, because of course we want to maximize the benefit to every child with an IEP. We want to help him reach his potential. And as of right now, districts, the law still looks at the Rowley standard as the controlling standard. Districts don't have to do that. They just have to help the child get their foot in the door. So, hopefully our states are moving along, and hopefully our court system will see that the IDEA has increased that standard, and there are high expectations, and that translates to a maximum opportunity. Now, some states do provide a greater standard, and it's okay for a state to decide, we want to raise the standard. We don't want it to be a basic 4. Depending on your state, you may have a state like that, then it's going to change. So, for example, in California, we follow that Rowley standard. It's still that basic 4 of opportunity. So as I often say to parents, it's unfortunately a bargain basement education. That's what the school district is obligated by law to provide. Now, there are ways to argue strategically, and we're going to talk about that later in this presentation, argue for a better education, calling it appropriate, of course, because appropriate is a very amorphous term. It's very subjective. What is an appropriate education for your child? It's going to be defined, in many cases, by independent evaluators. And that's where people like Dr. Perlman, who are going to talk about that process, come into play. What is his opinion, or another expert's opinion, about what is appropriate for this child? And of course, the school district would have its staff and its therapists and its psychologists, and they would define what an appropriate education. Ultimately, a FAPE is not, it is really only determined by a hearing officer or ultimately a judge. It's really hard to say that the FAPE can be defined. The IEP team does make a decision, but if there's a dispute, the only person that really decides that is going to be the judge. So everybody's going to theorize on what the FAPE is for this child. We're going to go to an IEP, we're going to talk about it amongst ourselves, and we're going to say, we feel that this is a FAPE for this child. The district is always going to make you a FAPE offer. Whether or not it's actually a FAPE is going to be up to a judge, because they're always going to tell you it's a FAPE, okay? So don't be fooled by that. If you walk into the IEP and that's the response that you get from the school district officials, that this is our obligation, this is what we have to provide you, that is just their definition of a FAPE. Could be very, very different from yours, and very different from an expert or an independent evaluator that you may hire to make recommendations for your child. Let's talk about number 6. Number 6 was a little bit disheartening, because I think that the U.S. Department of Education missed the boat. Under Part C of the IDEA, early intervention agencies are required to provide services to a child from 0 to 3. Okay? And if the child qualifies with a developmental disability, typically the child, there's criteria that's outlined. We're not going to discuss all the specific criteria right now, but the child qualifies for what's called an individualized family service plan. That child would have an IFSP from 0 to 3, depending on when the child is initially identified and when the IFSP starts. That IFSP could run for years, or it could run for months, or just a couple of weeks. Because sometimes the referral to the early intervention agency, and I'll tell you, in California, the early intervention agency responsible is the regional center. Not every state's the same. So in California, we call them the regional centers. But that early intervention agency is responsible to educate the child under Part C. So it is an educational program, but it's in the child's natural environment. Okay? And that could continue, or it used to continue, if there was a dispute between the parent and the school district when the child turned 3. Because when the child transitions from the early intervention program under this IFSP to the IEP, there's an eligibility determination prior to the child turning 3. There's a meeting that takes place, and the school district is obligated to make this offer of a free, appropriate education. Okay? So when the child turns 3, The district makes its IEP offer, its offer of FAPE, and then the school district has to determine, or the parents have to determine after discussing with the school district whether they feel that is a FAPE for their child. Does that meet their child's unique needs? And if it doesn't, you used to be able to say, look, school district, I don't like this IEP offer, okay? I'm not going to agree for now. And there would be what's called a stay put, and that's what we would call it, on the program that the child had under the IFSP. That has since changed, okay? You used to be able to keep that service, keep it beyond age 3. U.S. Department of Education said no, it's not intended, Part C is not intended to proceed beyond that age 3. So unfortunately, unless the parent accepts the offer that the school district makes, or portions of that offer, if you're in a state that allows you to accept the offer in part, now there is some federal law that we can argue allows you to do that, but many states have you, including California, give you the option of saying, I like this part of the IEP, I don't like that part, so I want to accept only this part. So if you're in a state like that, like California, that's a good thing, because you might agree with the therapy services, you might agree with part of the program, but you don't want to accept the whole thing, so the district would then have to implement only that part you agree to. If you don't agree to any of it, then you're kind of in a bind, because the school district doesn't necessarily, or doesn't have to keep that status quo, doesn't have to keep that IFSP going. So there are other ways to try to extend those services, and usually that has to do with your rights pertaining to the early intervention agency and filing requests for a stay of the services with that agency, but that's very state specific, okay? So if you're a California resident, I'd like to talk about how to do that. I'd be happy to discuss it with you, but it's not something I can go into a lot of detail and discussion about for other states. So those are the major changes, and looking at my watch, we have another 10 minutes, so I'm going to take questions right now about any of this stuff.
You had indicated that certain states have raised their standards.
Yes.
Do you know which states they will?
You know, I don't know every state. I know Florida, I had some clients in Florida, they had a higher standard, a maximized the benefit standard, but let me tell you, what's that?
Are you kidding?
Well, that's the standard officially, okay? But at least it was when I was representing. I don't have any clients currently. If it's changed, Florida did have one back about 3 years ago, last time I don't currently have any clients there. With respect to their obligations, the argument then becomes, what is that child's potential, okay? It now shifts from what is appropriate for this child. We understand their potential, but we don't have to help them meet that potential. The argument becomes, well, we disagree that the child has the cognitive ability or the intellectual capability that you're saying that he or she does. Okay, so they'll make you an offer based upon their interpretation of an IQ score or some other interpretation of a cognitive ability. Does that make sense? So then you don't have, yeah, we agree that he's got 105 or 110 IQ. We've got, no, we think he's at 80 and you think he's at 100. So we're going to make you an offer that maximizes the benefit at 80. Okay. So which state are you from? Maine. Okay. I'd be happy to look in that for you. If you email me.
The reason being my husband's being transferred.
Oh, okay. You're looking for a better state.
Well,
Yeah.
we're being transferred to the Midwest and we have flexibility. So
Okay. It's not always going to be a guarantee, and when I was representing clients in Florida, it was still just the same process of argument at the IEP. And it really did it was a shift to, we don't feel that she is as high functioning as you're saying she is. Our testing indicates that she's got a lower cognitive ability, therefore we're going to offer her a program that is commensurate with that cognitive ability. And that's the concern. I honestly don't know the specifics on Illinois. Does anybody know the standard in Illinois? Well, remember we talked about the court system and the fact that the IDA, we're arguing now, and like I said, that it hasn't been interpreted by the courts yet. I mean, it's starting to go up through the process. There's a case out of Western Washington that that has interpreted the IDA, and that's in the Ninth Circuit, but it's not mandatory authority that even applies to the Ninth Circuit because it's a district court case. It's a lower federal court case. But there is one case that's recently published out of Western Washington that's the court said the IDA 04 has a greater standard. Rowley doesn't apply anymore. The basic four, the foot in the door standard, the bargain basement education is not what you have to offer. You've got to offer a maximum benefit to the child. What's okay? Sure. Okay. Right. 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 Well, that's a good thing, hopefully. Why don't I talk to you, why don't you shoot me an email or we can talk after the session or after the panel discussion, further discuss? In the back. Yes.
We know that their IQ is actually much higher than the seventh grade, not expressive. So, how do you address that when we know that the potential's there, but on paper they're scoring extremely well?
That's a good Dr. Perlman question. He's back at 10 o'clock session. You want to save that question for 10? Go ahead.
Just the people in Illinois, the Illinois regs are going to be, should be approved for final. The new regs for the IE should be final for approval.
And what happens with states is you've got this sort of domino effect. You have the United States, the federal law that becomes effective, and then the states have to go around and change all their laws. So it mirrors, it doesn't conflict with the federal law. Even though it's okay for a state to give a greater benefit to a child because the law is intended to protect the child, it's not okay to give a lesser benefit. The federal law is going to trump if there's a conflict and it offers a lesser benefit. In some cases, states do offer that greater benefit, and that's where we had discussed at least Florida. And I'm guessing, but I think anybody from Massachusetts? You know the standard in Massachusetts? I had heard that it was a maximized standard. Okay. Okay, right here.
To answer that question about Illinois, I think all the goals are tied to the Illinois State Board of Education. So if she went into the
Okay.
But I have a question as well. I'm dealing with a district that is revising IEP goals that my son has.
I can barely hear you.
He hasn't met a particular IEP goal.
Okay.
And he just had an IEP meeting this past week, and they tried to dismiss that goal,
Mm-hmm.
revise it, so that way they could achieve it a lot easier. But the language of that goal, that took us a long time to come up with a year ago, was that he had to generalize motor skills across settings.
Mm-hmm.
So what they did is they changed the goal, because his progress has been very slow in getting there, and they just have him accomplishing the goal in P. Can I go back and tell them, no, I don't want this goal because
Let's talk about your question at the break, because I think I've got lots of other questions for you. Anybody have just a quick explanation question? I'm sorry, we're running out of time, and I want to make sure that we have enough time to take a restroom break. And one in the back. Okay.
I wondered if your organization would want to collaborate, maybe provide some advocacy groups or something, because I feel like we're alone there.
Sure. Very possible. I'd love to talk to you about that. Very possible. Yes? You can go to your State Department of Education's website, and if you Google search for, and you're in Iowa, Google search Iowa Department of Education, and you should get a link to the Iowa, Department of Ed website, and you can just click on laws, statute, regulations. Usually it's really easy to find. And if you can't find it, I'd call the phone number at the general line and just say you're a parent of a child with special needs. You've got questions about the laws, and they have consultants usually in the states that they'll connect you to, and they'll send you. You can get copies. At least in California, they offer free copies of the law, and most other states offer that too. And most everything is going to be available on the web. The web is a great resource to find information. It's kind of like trying to drink out of a fire hose sometimes. You know, it's a lot of information. You got to filter through it, okay? But it is a good resource.
I just want to point out another resource is every state has parent training and information centers that are federally funded. If you Google under parent training and information centers for Iowa, Illinois, any state that you're in will probably find a parent training and information center. They would know what's current in that state.
Mhm.
They also have probably a current copy of whatever the new rules and regs are.
Sure.
Special ed department.
Sure.
So in other words, the Raleigh standard was the foot in the door, and the new IDA 2004 is the rate standard.
Well, that's what we're arguing, okay? There's a difference. Lawyers like to argue positions, and we're arguing because I'm a parent lawyer that it has raised the standard, that things have changed, and that districts now have to offer a greater benefit, but it hasn't been tested by the courts. So until it gets up to at least a circuit appeals court level, this lady in the back was talking about 10th Circuit. California is in the 9th Circuit, and depending on what state you are, there's just, you know, we're going to be in different circuits, and sometimes the circuits even have different opinions. And 9th Circuit's always getting chided for being sort of the more, you know, off on their own side of the field circuit, doing their own thing, and so, you know, they might have completely different rules on some issues that haven't been particularly defined by the federal law, even though it's touched on, than other circuits. So that then the 10th or then the 1st or then the, you know, the 11th Circuit. 11 circuits. Yes, if the court grants review of that case. And like I said, it's very exciting. The U.S. Supreme Court has been taking a lot of special ed cases. We've got 3 in the last 3 years that the court's taken and decided. Not all of them have been good, but we're getting a lot of press in terms of at least they understand that these problems are in existence. They're out there. And they need to, and I'm hoping we get people who are a lot more parent-friendly on our Supreme Court in the near future so we can get some better decisions. Okay, I think we're at time. Yeah? Almost? A couple more minutes. Okay, a couple more questions. Question back here.
Do you know the name of the Washington State case that you mentioned?
I'll get that for you at the panel discussion.
Okay.
Yeah. Yes. California has been through a number of changes, and as a special education attorney representing parents, some of them haven't been so good. We had 2 major changes on July 1, 2005. We talked about the law IDA 2004 going into effect, but we had also a major shift from the agency in California that was making the decisions, the administrative agency that was deciding due process cases, shifted from a nonprofit called the Special Education Hearing Office to a state-run agency called the Office of Administrative Hearings. Okay, so you essentially have an arm of the state making decisions about these cases as opposed to an independent nonprofit agency under contract with the state, which is the way it was before. So we're seeing a lot of very green judges, I guess for lack of a better description, judges that really don't have any experience, background, or understanding of the procedural substantive laws controlling special education, making decisions about the future of the child. And that's very unfortunate. So we've seen a surge in appeals. And these are not appeals to circuit courts, because when you do a special education type appeal, you've got to do what's called exhaustion of your administrative remedies first. So you've got to take it to the administrative body that's been designated by the State Department of Ed to make decisions. And in our state, California, it's the Office of Administrative Hearings. When you get a decision there, if you don't like the decision, you can appeal it or request a court to review that decision and determine whether there was an abuse of discretion by the judge, the administrative law judge. I can't give you an exact percentage, but I will tell you, we are working on an article right now that will be published in a law at a local law school, at least California law school, that it'll be available for publication with all the most recent statistics. So if you send me your email address, I'll make sure you get a copy of that article. Okay, okay. Wonderful. Are you a parent or attorney?
Oh, I run Beacon Day School.
Oh, you run Beacon? Oh, you're Mary Lang. Okay,
Yeah.
good.
Okay.
Well, welcome, Mary. I've talked to you on the phone before, but we haven't met in person, so welcome. Any other questions? I think we just have maybe time for one more question. No more questions. Okay, we'll take a break. Everybody come back. We're going to start just a little bit after 9. What's that?